This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Okay, shall we start? We're down at the bottom of page 24, just this last case. D&C Builders and Rees. Mrs. Rees was having some building work done on her hotel. What are we in? Promissory estoppel. She was having some building work done on her hotel, and it was going to be a 6-week job, and the builders, we'd agreed the contract price, and they'd done a week's work, and then builders being builders, they said to Mrs. Rees at the end of the first week, can we have some money now, because we've bought all the material and we've paid the workers for a week? And she said, no, I'm not paying you now, I'm only going to pay you at the end of the contract when the work is done. So then at the end of the second week, they asked the same, and she said no, and they'd spent all this extra money, and they had to start borrowing from the bank and from their relatives. And it went on like this for 6 weeks, until at the end of 6 weeks, they were really destitute. They had no money left, but they managed to finish the job. And then they said to Mrs. Rees, there, now can we have the money? And she said, no, you can have it in 30 days' time. I'll pay you a check in 30 days' time, a written piece of paper that you take down to the bank and you pay it into your bank account. So I'll pay you a check in 30 days. And they said, no, we can't wait that long. You owe us £3,200. So she said, well, although the contract price is £3,200 payable in 30 days, what I will do is I'll pay you $2,400 now, cash. And they had to accept it because they had no funds left. So I accepted $2,400 and then managed to buy some more food, which they had not previously been able to do. And they repaid some of their debts, and they got back on their feet again, and they became financially viable again. And then he went back to Mrs. Rees and said, now you owe us the other $800. And she said, no, you can't claim that. I'm a victim of promissory estoppel. You promised me that if I paid you $2,400 now, that would be the end of the deal. And they said, well, no, why are you thinking that an early payment like that should satisfy the promissory estoppel principles? And she said, well, if I paid you something different in kind, that would have got me full discharge. And I did pay something different in kind. I paid you cash instead of a check, instead of this paper order to the bank. And it went through, eventually went through to Court of Appeal, and Lord Denning, she was unfortunate that she came up against Lord Denning. Lord Denning said, are you telling me that you think that cash is something different in kind than a cheque? And she said yes, and he said, well, no, in fact, it's not different in kind, and you do owe the other £800. Just because you paid a smaller amount, just because they promised that you would get full discharge of the debt if you paid £2,400 cash instead of £3,200 cheque, that's not right. You still do owe that money. So even though they accepted it, they only accepted it reluctantly. They didn't want to accept. They were not volunteers to accept this earlier payment, this payment in kind, this payment in a different nature than the amount that had been agreed. Okay? Which gets us on then to page 25, intention to create legal relations. Intention may be specifically identified, or it may be implied. And it's presumed that there is intention unless we can rebut that presumption. And the world of intention splits into two: family and other. And family itself also splits into two: husband and wife and other family. And husband and wife splits into two: living together and living apart. And when I say living apart, I don't mean you're living here and your husband is working in Germany and therefore you're living apart. I mean living apart as in separated or divorced. Well, then you're no longer husband and wife, are you? Living apart, separated rather than divorced. So we're going to look to begin with at domestic arrangements, husband and wife living together. We're coming down this left-hand side. I wish this pop-up would disappear. Don't show me this message again. Well, domestic arrangements, husband and wife living together. And a couple of cases there, Balfour and Balfour. And Spellman, Spellman. And these, of course, are in your case list, where the plaintiff and the defendant have got the same name. Balfour was about a husband and wife living together. He had a job as a manager of a tea plantation in Sri Lanka. And they were out there together, and then they came back to the UK for a holiday. And when it came time to go back, she said, I don't want to go back. I don't feel well, and I don't want to go back and live in that steamy atmosphere of heat and rain every afternoon. I don't want to go back there. I would rather stay in the UK. And he said, all right, I understand, but I have to go back. I have a job. I'm in a contract to be a tea plantation manager, so I have to go back. But what I will do is I will send you £10, or I remit £10 to you every week in order that you should be able to continue to survive. So he went back to Sri Lanka. The agreement was made while they were husband and wife living together. Now we have a little bit of a technical problem here in terms of what is understood by the expression living together. And living together does not simply mean still living in the same house under the same roof. And it's even further than sleeping in the same bed. It's actually enjoying the fruits of each other's bodies is living together. I don't know how else I can say this without getting deeply embarrassed. So living together is where husband and wife enjoy, inverted commas, normal marital relations. And at the time of this agreement, they were living together, and he went back to Sri Lanka. But of course, Sri Lanka is a long way away from the UK, and people have their needs. And he found a way of satisfying his needs when he was in Sri Lanka, and don't know whether she did in the UK. But eventually he writes to her and said, I'm not sending you £10 anymore, and I found another young lady who will care for my desires. So she sued for divorce, and she sued also on the basis that he'd now stopped paying her £10 per week, and she demanded that this continue to be paid. And the court said, what was the state of your marriage at the time of this agreement? And she said, we were, inverted commas, living together. And the court said, well, a husband and wife who live together are treated and were treated at the time, I'm not saying they will be treated the same now, but they were treated as a single unit. And if you think of yourself as a single unit, how can you contract with yourself? And therefore, husband and wife living together, it is presumed that there was no intention to create legal relations. And therefore it's not an enforceable contract, and therefore she couldn't get her £10. Husband and wife who live together are treated as one. Spellman and Spellman is, again, a husband and wife living together. They live out in the countryside away from the main city, and she has no transport, and it's a long way to walk to the bus, to catch the bus into the city to see her friends and share a coffee, and she's bored. And she said eventually one evening, she said, I am so bored living out here. I've got nothing to do. I have no friends out here, and I'm a prisoner. I can't get into town for relaxation. I can't get into the city. So I said, all right, darling, I'll buy you a car. So he bought a car in his name. He insured it. He put fuel in it. He taxed it. And things got better for a while. But eventually she said, I'm still bored, but this time I'm bored with you. So I'm leaving. And he said, okay, if you set off now, you possibly will just catch the last bus. And she said, I'm taking the car. And he said, no, you're not. She said, but you promised that you would buy me a car. And he said, yes, but we were living together at the time, and that's therefore not an enforceable promise. There was never any intention to presume that I was intending to create legal relations. So she sued. She wanted the car. And the court said, at the time that he promised to buy you this car, what was the state of your marriage? And she said, we were living together. And the court said, well, therefore, there is no presumption of any intention to create legal relations, and therefore you can't keep the car. He bought it, he paid for it, he fueled it, he taxed it. It's his car. Oh, life is unfair, isn't it? So we have the general principle then that husband and wife who are living together, there is no presumption of any intention to create legal relations. You cannot contract with yourself. But husband and wife living apart is a different matter. And we have the case merit and merit. And this time the couple is already separated. He's already moved out of the marriage home. But of course, when a relationship breaks up like that, you've got a lot of mess to sort out. And part of the mess was, how are we going to continue to pay the loan for the house? So she phoned him at work one day and said, can you come round? We need to sort out an agreement about the house and who's going to keep the house and who's going to pay the loan. So he said, yes, okay, I'll come round at 7 o'clock. She said, well, when you arrive, just sit in the car outside and I will look out for you. I'll come out to you. I don't want you coming in the house. I don't want you upsetting the children. So he arrived at 7 o'clock and she went out to meet him. And they did reach an agreement. She said, I will pay the mortgage, I will pay the loan, but if I take on the responsibility of paying this loan, I want you to transfer to me your share of the house. So that was what the agreement was, and that was settled. And she did, she paid off the loan. And then when she asked him, he refused to transfer the house. He refused to transfer his share. So she sued. And the court said, when you reached this agreement, were you living together or living apart? She said, we were living apart. Now, as a married unit, you are one, but as soon as you divorce or separate, you become two people again. And therefore it is presumed by the court, husband and wife living apart, there is intention to create legal relations. And therefore she did get her share of the house. There's a little bit of awkwardness in that the law of property, which is not in your syllabus, says that an agreement to transfer an interest in property must be in writing, or must be evidenced in writing at least. And there was no evidence in writing about this agreement. But this is beyond your syllabus. This is just me talking while you're continuing to write. But the courts have been prepared to say, even though there is no writing or no evidence in writing, if you can show that the acts of one party are in accordance with this alleged agreement, then the court is prepared to do without the requirement for evidence. So it was an oral agreement to transfer his share. She could show the court that she had paid off the loan, and therefore the court says, well, why would she pay off the loan on her own if she was not going to get her share of the house? So her acts supported her claim that he had agreed to transfer his share. I think that's a good decision. But you, ladies, gentlemen, you really need to think hard before you take that divisive split. You need to think out, am I going to reach an agreement now, or shall I leave it until next week? Domestic arrangements other than husband and wife, so we've got at the top of the screen there, husband and wife and other, family arrangements, domestic arrangements. The case Simpkin and Pays, Jones and Paddavatten, Parker and Clark. I'll only go through one of these. We'll have a look at Simpkin and Pays. This was a grandfather-granddaughter. And a third person who lived with them. Not in any sexual connotation, it was just a person who rented a room within the same house. A person called a lodger. I don't know if you know the word. A lodger. A person who lodges, who stays with you in your house, but it's not family, it's just a person who pays you a weekly or monthly rent to live in a room in your house. And these three, the lodger, became quite close with the family. They would share evening meals, they would watch the television together, and they also had an interest in entering newspaper competitions. And they won every now and then. They won a little bit here, a little bit there. They would share the proceeds of the winnings. And then one day they entered a newspaper competition with the Daily Express, one of the daily newspapers in the UK. They entered a Daily Express newspaper competition in her name, in the granddaughter's name, and they won. And they didn't just win a little amount, they won £600, which was a substantial amount at the time. And the granddaughter said, aren't I the lucky one? This entry form is in my name, this £600 is mine. And the lodger and the grandfather said, well, no, come on, we've always shared in the past, even though it's only been £5 here and £3 there, it's always been shared. And she said, but this is in my name, this £600 is mine. So the lodger took the granddaughter to court, and the grandfather supported the lodger. And it went to court, and the court said, well, although it's a domestic arrangement, although it's a family arrangement, it is historically able to be shown that you have in the past always shared the winnings. And therefore it is presumed that you intended to continue sharing your winnings. And the granddaughter had to pay the money over to the lodger and the grandfather. Jones and Paddavatten you can look up for yourselves. It's about a woman from Bermuda living in New York, and her daughter was studying law in London. You put it into Google, you'll find the story. Parker and Clark was about an auntie and a niece. And again, I want to move on, so I don't want to get into it. It is presumed, it depends on the circumstances. It depends whether there is or is not intention. Jones and Paddavatten, it was held that there was no intention to create legal relations. Whereas Parker and Clark, it was held that there was intention to create legal relations. So it depends on circumstances, it depends on the facts of each individual case. Commercial agreements, it is generally presumed, unless stated otherwise, it is implied within a commercial agreement that there is intention, but the commercial agreement itself can set that intention aside. In the event of dispute, we will resort to arbitration. In the event of dispute, such an amount of money shall be paid. In the event of dispute, no legal rights will attach to anything. So you can set aside the presumption to create legal relations. And that's what happened in the case Rose and Frank and Crompton. And express exclusions, we've got these two cases, Jones and Vernon Pools and Appleson and Littlewoods. There used to be, I don't know if it still exists because the lottery seems to have taken over, the National Lottery seems to have taken over the gambling urge of the UK people, but there used to be a system where you could predict the result of 16 out of 55 football matches every week. And if you got 8, if you predicted 8 draws, 8 scores were of 1-1 or 2-2 or even 0-0 at the time, if you could predict 8 in your choice of 16, then you got you won what was called the first dividend. And it could be millions. There were people that would win 5 or 6 or 10 million because they were the only ones and there were only 8 draws that week. And if you happened to select them in your 16 choices, then you were a winner, and a big winner. But because of things like the postal rule, you have to set aside the possibility that there is any intention. Because if I sit there on a Saturday afternoon and I complete this document and take a copy of it and then pretend that I've posted it in the postal system and it's apparently been lost, then I potentially got a valid claim against the pools company, it's called the football pools. It would mean I've got a potential claim against the pools company. So it specifically says within the document there is no intention to create legal relations, and therefore if it is lost, that's just hard luck. It really is hard luck. If you were an 8 million winner and your entry form is lost, you've nothing you can do. There's no claim you can make. So it is available within any contract, specifically, expressly, to set aside intention to create legal relations. Carbolic, down at the bottom of page 25, Carlyle and Carbolic, was their intention? Well, they denied that there was any intention, but of course because they'd paid their £1,000 into the separate bank account, the court looked at that and said, well, why would you? Why would you have paid this money if you had not intended to create legal relations? Representations, page 26. Representations are not terms of a contract. They're not part of a contract. There is a question that says distinguish between terms in a contract and mere representations. Well, terms of a contract are actually the meat of the contract agreement. Representations are pre-contractual statements made with the intention of inducing another person to enter into a contract. I can talk to you about how wonderful ACCA is, and it's a worldwide recognized qualification, and you can come on courses, and hopefully we will get you through the exams, and this is what the cost is likely to be. But these are all mere representations. These are trying to persuade you to sign up to come on courses. Only when you make your decision and say, I want to register on a course, do we then start talking about a contract. So you cannot rely on anything that I say before that contract. This is a mere representation trying to persuade you to enter into a contract. The pre-contractual statements then, second bullet point, of some known or provable fact made with the intention of inducing another person to enter into a contract.
How does representation have invitation?
An invitation is inviting you to make me an offer. A representation is persuading you of the general advantages of entering into a contract. So I suppose in that respect they are similar. I think maybe you could say that representations were invitations. But you can't say that invitations are representations, because a packet of cornflakes on a supermarket shelf is not a representation. But notice it's pre-contractual statements of some known or provable fact. It's not a statement of law. It's not a statement of opinion, unless it's clearly the wrong opinion. In which case, The representation of a wrong opinion becomes a misrepresentation, and a misrepresentation entitles the innocent person, the wronged person, to take action and probably rescind the contract. I'll tell you about rescinding when we get there. It's a strange word, rescind, and the noun after rescind is a noun called rescission. To rescind is the verb, and rescission is the noun. And we'll get to them in due course. Bissett and Wilkinson is the case I've given there. It's clearly not a genuine opinion. Bissett and Wilkinson. Bissett and Wilkinson was about the sale of a piece of land, and the seller said that the land was big enough to support a flock of sheep of, say, 2,000 sheep. And in fact it wasn't. 2,000 sheep very quickly ate all the grass, and there was no further grass growing. So the land was not big enough to support a flock of 2,000. It was a wrong opinion, and it was therefore a misrepresentation made with the intention of inducing another person into a contract. And the buyer was able to rescind that contract, to negate it, to cancel it. To rescind in this context means to cancel. It means you can go back and undo the contract and put yourself back in your original position as though you had never entered the contract. That's the effect of rescission. So it's a statement, a pre-contractual statement to some known or provable fact. It's not law, it's not opinion, it's not a statement of intent. A statement of intent is not a representation unless it clearly does not truly represent your intentions. If you say it is my intention not to open a competing cafe down the road, whereas in fact it clearly is my intention to open a competing cafe down the road, then that would be a misrepresentation. A false statement of intent is a misrepresentation. But a statement of intent itself, if it is the genuine statement and genuinely reflects your future activities, then that would not be a representation. Which gets us on to page 27, contractual terms.